Well, thank you very much for coming today. Today's a very important day for attorney generals across the state. This morning, the government will initiate their oral argument with regard to their motion to dismiss the health care lawsuit. There are 20 states currently in that litigation in Pensacola, separate from the litigation in Virginia. 4 of those states are represented through their governor as compared to the attorney general, and Georgia, unfortunately, is one of those 4 states that did not have the assistance of the attorney general and that had to go through this process through the governor. This is an unprecedented intrusion on state sovereignty. There are 3 elements to the health care law: the political element, the legal element, and the financial element. The political element is simply whether or not government ought to be in the national health care business, and I, for one, feel that that's totally inappropriate and that we should not be trying to do what the private sector can do much better. Secondly is the legal, and both from the perspective of the individual mandate as well as the cost on the state, there are significant constitutional concerns. They relate to Article 1, Sections 2, 8, and 9. They relate to the 5th Amendment. They relate to the 10th Amendment. You know, we're used to paying income tax, we're used to paying property tax, we're used to paying sales tax. We may not like it, but we're accustomed to it. But with the health care bill authorized by this president, for the very first time, we'd be taxed or penalized for the failure to buy something. Now, when I was in lawsuit, interstate commerce didn't take a lot. Literally, it took a product crossing state lines and you could invoke the Commerce Clause. With this legislation, it's the failure to buy a product that is allegedly invoking the Commerce Clause, which is nonsensical. By definition, the failure to buy a product cannot institute the Commerce Clause or invoke the Commerce Clause. Additionally, this act is trying to dictate state policy. The states have to create insurance exchanges, which in essence is totally removing the healthcare insurers from their practice. Secondly, it's requiring states to provide additional fringe benefits to their state employees, which frankly hasn't been well covered by the press to date. And thirdly, the expansion of Medicaid, just for our state alone, has an additional cost of $1.4 billion. So there's the political issue, the legal issue, and the financial issue. Of course, it's the role of the Attorney General to be most interested in the legal issue. And the question becomes whether on principle, as the Attorney General is sworn to uphold the law, is sworn to uphold the federal Constitution and the state Constitution, whether you're going to do that. And I would suggest to you that the current Attorney General, in deciding not to be a part of this litigation, has abdicated his responsibility in this regard. And my opponent similarly agrees with Mr. Baker and believes that we should not be part of this litigation. You know, elections have consequences, and I would suggest that it's vital to the interest of Georgians and their values that we in fact actively be engaged in this litigation. If the failure to buy a product is commerce, then there is nothing Congress cannot do to the states and its citizens. So this case has an expansive effect on the intrusion by the federal government and is very detrimental to the interests of not only Georgians, but the Georgia state government. Earlier, the judge in Virginia ruled against the government's motion to dismiss. And it's certainly my expectation and my hope that Judge Vinson in Pensacola will similarly rule against the government, and this will go to a full hearing thereafter the appellate courts to include the U.S. Supreme Court. This is not, quote unquote, a partisan issue. This is a bedrock constitutional issue of what the 10th Amendment stands for. And we need to defend it in Georgia just as the other 22 states are defending the 10th Amendment. And at this time, I'll be happy to take any questions that you have.
See, but this is not a partisan issue. Why does it appear that the Republicans are willing to go to bat to fight this and the Democrats are not?
Well, there are a couple Democratic AGs that are fighting it with the Republicans, but clearly it's predominantly been a lawsuit by Republican attorney generals. And I think the issue is simply, once again, they don't want to be seen going against their own president. But I would suggest to you that the U.S. Constitution isn't Republican or Democrat. The Georgia Constitution isn't Republican or Democrat. And the intrusion by this law to not only order additional programs to take over 1/6 of the nation's economy, to have an effect on the fringe benefits you provide your state employees, is wholly above what we want a federal government to do. There were 2 cases in recent years, U.S. v. Lopez and U.S. v. Morrison, that specifically held that the federal government is going places they should not. One was the drug-free zone and one was the Violence Against Women Act. We're all for less violence. we're all for drug-free zones, but that is in the realm of state government rather than federal government. And for too long, states have frankly not done their job, and the attorney generals have not done their job. It's vital that we, in fact, defend the Constitution, which is the basis of these two lawsuits in Virginia and in Florida. Any additional questions?
Are there limits to our states' rights?
Oh, absolutely. I mean, the 10th Amendment specifically says those powers not specifically enumerated in the Constitution rest with the state. I'm not seeking that the states assume rights that are guaranteed the federal government. I'm simply requesting that we follow federalism, that we follow the Federalist Papers, that we in fact follow the wishes of our founding fathers. For those areas where the federal government is best suited, I want the federal government to handle it. But for those areas where the Constitution expressly says it's not the role of the federal government, I want them out of it. I want Georgia citizens and the legislators in our state to be handling those issues.
There was a debate last year, Mr. Olens, about whether the Attorney General should have acted at the request of the governor constitutionally. What's your interpretation?
It's clear when you look over the article in the Constitution as well as the statutes that they're concurrent. Both the governor and the Attorney General have the right to bring such litigation, and that's essential. It's really necessary to have those proper checks and balances. The Attorney General is the state's lawyer. But it's essential that when the Attorney General chooses not to be involved in litigation, rightly or wrongly, that the governor have that opportunity to represent those legal interests through special counsel. So I would suggest we have it right in Georgia that provides that balance. They're both constitutional officers. They both have the ability to represent the state citizens. It's a shame they're not working together at this time, but the way we have the law in Georgia is in fact the correct way.
Sam, we're in an unprecedented budget crisis here in Georgia. Is this something that Georgia can afford to do, and how much is this fight costing the state?
Well, first of all, thanks to Frank Jones and the team that Frank's working with, the legal fees are zero. The only thing we're frankly paying for some accessory fees. Keep in mind, when you talk fees, Medicaid per year is estimated at least $1.4 billion. The cost for the additional state fringe benefits I mentioned, they frankly don't have a good actuarial analysis. That's over and above the $1.4 billion. I assure you that the cost of legal fees isn't in the billions of dollars, but the effect that this bill has on our state annually is in excess of $1.5 billion. So I think that's frankly an argument that has been expressed by both the current Attorney General and my opponent, but one that holds no water. When you're talking about principle, when you're talking about an infringement, an intrusion on state sovereignty, is $100,000 too much to spend? When it's going to cost the state over $1.5 billion a year to comply with the law, is $100,000 or $200,000 too much to spend? You have to stand for principles, and the attorney generals are there to defend the constitutions. Yes, sir.
Well, I'm sorry. What about the average Georgian? What impact will this have on them, in your opinion, who are paying for their own or will have to pay for their own?
Well, first of all, we're already seeing significant premium increases. We're already seeing changes to the insurance coverage. So the effect of this terrible bill is already known now. You don't have to wait till 2014. Under the bill, by definition, most employers will no longer cover employee health insurance. If you have the ability to pay an approximate $2,000 penalty as compared to pay approximately $10,000 to cover the employer portion of the insurance, what are you going to do? That's why Walmart was so much in favor of this bill. You save the $8,000 by paying the penalty or tax for the $2,000. But someone's got to pay that extra $8,000. It's you and me. It's the taxpayers that are going to get stuck with this bill. And the unfortunate thing is there aren't the revenues in this bill to pay for it. So once again, we're just adding to the country's debt in an effort to appease the president and national health care. There's nothing really worse at this time than adding to our debt for a program that the majority of our citizens don't want, separate and apart from the constitutional issues. So what you're going to see is the employers are going to say, sorry, we were really happy to give you this coverage, but we can't afford it under the president's health care bill. So we're now going to be put in an insurance exchange. And I would suggest to you, if doctors and hospitals are dissatisfied with Medicaid payments now, When you add that whole extra subset that's going to be eligible for the exchange, the payments are even going to be far less than they're receiving now. So the real issue is how many doctors are going to retire? How many doctors are going to decide they want to go into another profession so they can pay their bills? This doesn't increase access to health care. It's going to actually reduce access to health care. We already have doctors retiring now that have said, I've had it. I'm not going to deal with the system anymore.
Considering where the state is and where it's moving, and moving a lot more red, do you believe that your opponent is just not following the will of the people?
Well, it's interesting. My opponent is running more to the left since the primary rather than more towards the center. He wants a new civil rights unit for the Attorney General's office. He keeps coming up with new programs when the state doesn't have sufficient money for the essential programs now. I would suggest to you that the Attorney General has plenty on its plate already. You've got the special session with reapportionment coming next year. You've got the healthcare litigation. You've got the immigration issue. You've got numerous issues on the plate of the Attorney General now. Now's not the time to be increasing programs or going against businesses. Now's the time to frankly help businesses stay in business, to help them grow business. And it's very disappointing to see that my opponent wants to be more like many of the Attorney Generals in the Northeast that sees their job as frankly going after businesses. You know, we have 10% unemployment in this state. The last thing we need is an Attorney General who's going to discourage new jobs in our state.
Is the Attorney General involved in the healthcare litigation now?
No. It's now totally through Frank Jones, who was the special counsel appointed by our governor.
They're not involved in any way?
No.
All through the governor's office?
All through the governor's office, 100%.
Would you somehow, if you were elected, how would you get involved? If the litigation's
Well, January 10, first of all, we changed the style of the lawsuit to put it in the name of the state of Georgia rather than the governor. The governor did exactly what his option was, and I greatly appreciate his leadership on this issue. But we ought to be like the other 16 states in this litigation where it's on behalf of the state. So number one, we would do that. Number two, I'd certainly ask Frank Jones to continue on. He's providing great leadership, but I'd like there to be some folks from the Department of Law assisting Frank Jones and his committee at that time. We're not talking about additional cost. We're talking about more collaboration of lawyers.
From what they were working on now.
But consistent therewith. By that I mean you'd have a couple lawyers in the Department of Law working with Frank Jones and his advisory team. So I don't see it as an additional cost. I see it, frankly, as more collaboration between the Department of Law and the team that's now handling it on behalf of our state.
Sam, what is a win-win situation?
I apologize.
What is a win-win situation for the people of Georgia in your opinion?
Well, frankly, it would be the repeal of the health care bill. But by definition, that's not available at this time. So I would suggest that the first route is the legal route, which is what our governor sponsored with the special attorney general. You go through the legal process. Additionally, you ask our congressmen like Tom Price and Phil Gingrey to keep up their leadership and to see about not funding this monstrosity. And thirdly, look for other avenues in which to provide access to health care bill that's not in this bill. For instance, there was talk about permitting insurance policies across state lines. Everyone agreed to it, but it wasn't in the president's bill. People talked about portability, that when you leave your job, you could continue your current insurance policy. That's a great idea. We should have it. I recently had to pay for COBRA when I resigned from Cobb County. COBRA's an interesting cost. The ability to have the portability would be much better for our citizens. So I think we ought to go back to the starting line again with access, with portability, the issues that everyone agreed to, rather than those issues that few agreed to. We ought to frankly include tort reform also in the legislation. There's absolutely nothing in this legislation to reduce the cost of health care.
So for repealing, is it an option that you see just parts of it being struck down in the courts? How do you see this playing out?
Well, you know, candidly, I'm not going to make believe I'm the U.S. Supreme Court. They could, in fact, repeal it entirely. It is most likely that they would strike out different sections. But the problem is at the same time, The state's already working on prospective insurance exchanges. The states around this country are already needing to work as if this bill is constitutional and going in effect 2014. Some may sit there and say, why are you suing now when it doesn't take full effect until 2014? But the exchanges and other steps required by this bill are requiring state action now. So it's essential that the lawsuit be filed as quickly as possible.